Okay, we're going to start by looking at agency law, looking at the agency relationship and third-party relations of the principal and the agent. H. Ross Perot, which some of you may remember, or you might be too young for this, ran as an independent for president. He's also a large business owner and has been very successful throughout his life, and this quote is attributable to him. The learning objectives, the first half, are creation of an agency relationship, agency concepts, definitions and types, duties of the agent to principal, duties of the principal to the agent, and termination of an agency. Some of you may remember some of these concepts and terms from contract law and legal environment. The other half is learning objectives are about contract liability of the principal and of the agent, contract suits against principal and agent, tort liability of the principal, tort liability of the agent, and tort suits against principal and agent. And we'll get into these in a little bit more detail as we go along. So an overview is that agency is everywhere. You actually deal with agencies on a daily basis. Agency is a two-party relationship in which one party, the agent, is authorized to act on behalf of and under the control of another party, a principal. Those of you who are employed are agents of your employers. And as the saying goes, all employees are agents, but not all agents are employees. If you go to a restaurant, the person serving you at the restaurant is an agent of that employer. So first let's start with the creation of the agency. Anybody may be an agent or a principal, but the agreement is voidable by minors and the mentally incapacitated. So basically what they're saying here is that it doesn't matter what your age or capacity is, you are allowed to be an agent or principal, but if you remember under contract terms, voidable means it's at the option of the minor or the mentally incapacitated or someone acting on their behalf, such as a parent or a guardian, that they may void the contract, but it's not necessary. And certain duties are non-delegable. For example, a surgeon cannot delegate his duties to the pizza delivery guy to perform his operations. Certain skills are very specialized and are non-delegable. And then we're going to look at agency authority. An agent can bind his principal only when the agent has the authority to do so. So there are two forms of agency authority, actual and apparent authority. Actual authority is either express or implied. So express authority is created by the principal's actual words, and they can be written or oral. For example, I want to hire you as my real estate agent to sell my house. And when is a writing required? We talked about that the agency can be created by writing or oral, but in some cases, as you learned in contracts, the statute of frauds applies, and in that situation, the agreement must be in writing. So for an agency, the same situation applies. In these situations, when the agent is creating an agreement that in itself would be subject to the statute of frauds. So if the agent is creating any agreement that cannot be completed within 1 year of its making, then it must be written. Any agreement that answers for the debts of another, any agreement in consideration of marriage, any agreement that involves an interest in real estate that includes leases, rental agreements, sale of land, etc., and any agreement for the sale of goods equal to or greater than $500, and that falls under the Uniform Commercial Code, Article 2. Implied authority. Now, we were just discussing express authority, but this is implied authority. An agent has implied authority to do whatever it is reasonable to assume that the principal wanted the agent to do given the principal's statements and surrounding circumstances. For example, a person hired as a general manager in a restaurant will have broad authority to run the business, while a person hired as a waiter will have limited authority. Another example might be that an agent is tasked with purchasing, let's say, 10,000 widgets for the principal. And he's been tasked with this expressly, it's written down, but there's no mention of how he's to pay for these widgets. So the agent has the implied authority to take out credit on the principal's behalf to pay for these widgets as part of his agency duties. And now we're looking at apparent authority. Apparent authority arises when the principal's conduct leads a third party to believe that an agent who lacks actual authority is authorized to act a certain way, and the third party reasonably relies on the appearance cloak of authority. To protect third parties, agency law allows agents to bind a principal on the basis of apparent authority. So if you go into a convenience store and there's a person behind the counter, they're wearing a blue vest, they're operating the cash register. Nobody has told you that that person has actual authority, but he is cloaked with apparent authority. And whether or not that apparent authority is real, you can reasonably believe that if you give that money to pay for your gas to that individual, that person has the authority to put in the cash register and act on the owner of the convenience store's behalf. A big question or a legal question comes as to whether someone is an employee or an independent contractor. And that depends on whether a person who contracts with the principal is an employee or independent contractor, because certain legal issues arise whether they're one or the other. There was in common law no clear distinction, but the case of Eisenberg v. Advanced Relocation and Storage, Inc., the court lists the Reed factors to aid in decision making. So when they're trying to determine if someone is an employee or an independent contractor, you'll look at the right to control the physical details of their work, the skill required, the source of tools, location, schedule, control, duration of the relationship, payment method, benefits, tax treatment of the hired party, and uniqueness of the work. This sometimes comes into play when an employee, for example, is suing their employer for, let's say, sexual harassment, and they're suing as an employee, and the employer says, well, they can't sue as an employee because they were an independent contractor. So in that case, because certain duties arise on behalf of the employer in terms of an employee, that they go back and the court will look at these actual Reed factors to determine whether this person was actually an employee or an independent contractor. Another type of agency that arises, and you can see this also in your daily life, you tend to see it more with family members that are becoming incapacitated or ill, or parents that as they become older. It's called the power of attorney. A power of attorney is a formal appointment of an agent that must be signed by the principal. So it's a formal written document. There's no exceptions to it not being written. And even though it's called power of attorney, it does not require an actual attorney. So any individual can serve as the attorney for the power of attorney. A general power of attorney authorizes the agent to do anything that is necessary to transact the principal's legal affairs. So as we're saying here, that's the general power of attorney. We also have a special power of attorney, and that grants authority for specific enumerated acts. So you might give someone power of attorney, let's say if you're leaving the country and you want your sister or brother to carry on whatever financial matters take place while you're out of the country, let's say for a year. In that instance, they would only be able to handle, let's say, financial matters because that's the specific enumerated acts. So they can't do anything beyond that. And under common law, a power of attorney ends upon the death or incapacity of the principal. Now we've gone further with that with statutory law, and we'll discuss that in the next slide. And that's called the durable power of attorney. Most states have some form of durable power of attorney statutes. And the durable power of attorney is effective in the period of incapacity of the principal if the power was conferred in writing that expressly provides for the agency to continue after the principal becomes incapacitated. So if the written document signed by the principal does not make any express statement that it's to continue in the event of the principal's incapacity, then it's not a durable power of attorney. It cannot be used as such. In some states, and Georgia is one of them, a durable power of attorney can function as a living will, which allows the agent to make financial and or health care decisions on the principal's behalf in the event the principal becomes incapacitated. So in Georgia, you can have what's called a durable power of attorney for financial matters. You can have a durable power of attorney for health care, or you can have a durable power of attorney, which is also referred to as a living will, which handles both financial and health care decisions. That durable power of attorney must specifically enumerate what activities or what decisions you want the person acting on your behalf to perform for you in the event that you become incapacitated. Now let's look at the duties of the agent to the principal. Since the agency is a fiduciary relationship of trust and confidence, an agent has a duty of loyalty to the principal. So they must do two things. One, they must avoid conflicts of interest with the principal, and two, they must maintain confidentiality of information received from the principal. And even if the agency is terminated, the duty of confidentiality survives the agency. So if you're working on behalf of an individual or on behalf of a corporation as their agent, and at some point along the line, the agency is terminated for whatever reasons, if you have client lists, customer lists, you have special tools, or of trade secrets, you are not allowed to release those legally without having breached your agreement, and in that case, you are liable to the principal. Excuse me. In self-dealing, that's an example, is the principal appoints you as agent to sell one of their classic cars. Let's say it's a 1965 Mustang, and they're asking $35,000. Well, you go out and you find a buyer, but you tell the buyer it's $40,000, and you pocket the $5,000. Now, if you pocket the $5,000 and the principal never knows about the $5,000, that's self-dealing, and you've breached your duty to the principal. However, if the principal tells you, listen, I'm wanting $35,000, but if you end up selling it for more, you can keep the difference. You still have the duty to disclose if in fact you sold it for more than $35,000, but that in itself is not self-dealing. Competition with the principal is where you're acting on the principal's behalf, at the same time you're acting in your own best interest, and you're competing in the same exact manner that the principal has employed you under your agency agreement to perform on their behalf. Or acting for another party. Excuse me. Acting for another party is talking about that you're representing multiple people, multiple companies that may be in competition with each other, and you haven't disclosed that to all the parties. The exception to this would be an independent insurance agent, because they, by nature of being independent, they will have disclosed to all of these other insurance companies that they're selling insurance on all of their behalves. But otherwise, you can't act for another party when you're acting in competition with another principal. These duties, however, end after the period of agency, unlike the confidentiality ones we discussed earlier. Now, these are some more agency duties, agent duties. They must obey the principal's reasonable instructions for agency business, exercise the degree of care and skill standard for the job, promptly communicate to the principal matters that are reasonably relevant or material to the agency business, and duty to account. Duty to account means that they must disclose all financial matters associated during the course of their agency agreement. But they have no duty to obey illegal or unethical orders. In the case of Sanders v. Madison Square Garden, the defendant employer countered employee's lawsuit with what's called the faithless servant doctrine. That's where the employee allegedly acting unethically or operating a side business, such as moonlighting. In that example, the person was working in the employer's facility after hours and making money, and that's called the faithless servant doctrine, and was not disclosing that to the principal. So the faithless service doctrine will apply if the worker's disloyal acts were related to the performance of duties and somehow the employer suffered damages. And those damages might be that the employee was selling items out of the facility that should have been a part of the employer's business. Same thing happens if the employee ends up damaging the employer's facility, or if the employee is acting illegally and the police bring charges, then the individual who'd be liable would be the employee and not the employer. Now we're going to flip it and look at duties of principal to the agent. A written agency contract normally states the duties of the principal owes the agent, but the law implies certain duties on the principal. So if you have a written agency contract, that's going to spell out most of the duties. But absent those being spelled out or absent a written contract, common law implies certain duties. The principal must compensate the agent. And they must reimburse the agent for money spent in the principal's service, and they must indemnify the agent for losses suffered in conducting the principal's business. Okay, now we've looked at both duties of the principal to the agent and the agent to the principal. But what happens when we need to terminate the agency for different reasons? Termination by act of the party includes at a time or event stated in the agreement. So if the agency agreement says you're going to represent me as my sports agent for 2 years, then at the end of the 2 years, both parties are able to separate and go their separate ways. When the agency was created to achieve a special purpose and the purpose was achieved. For example, the principal employs the agent to find a building which the principal is going to operate and open a new business. So once the building is found and the business goes into operation, then that special purpose has been achieved and the agency agreement terminates. By mutual agreement of the parties, so the principal and the agent might be working together for a while and they come to the conclusion that they no longer are in need of each other's services and they agree to end the agency agreement, or at the option of either party. So without something expressly written in the contract or a written agreement, then either party may terminate the agency at their discretion. Now we have a special agency, which is like called an agency coupled with an interest. In an agency coupled with an interest, the agent has a specific current beneficial interest in the property that is the subject matter of the agency agreement. The subject matter of the agreement is the item in which the agent has authority and has an interest. And this kind of agency is revocable. Unlike other agency agreements, this type of agency is created primarily to benefit the agent versus the principal. For an example, Dan borrows $100,000 from the bank and he puts his property up as collateral. So the bank holds the property in security in the event that he defaults on the loan. So even though Dan is the agent in this case, the benefit is for him because he got the money from the bank. So this is an example of an agency coupled with an interest. Now further, a termination of an agency, the termination by operation of law includes when there is a serious breach of the agent's duty of loyalty, such as a breach of confidentiality or a conflict of interest, the principal's permanent loss of capacity or agent's loss of capacity to perform agency business. So if the principal has a business operation and they've employed the agent to go out and help them build this business, and the principal becomes permanently incapacitated so that they can no longer perform their business, then the agency will be terminated because there's nothing that the agent can further sell because the principal is no longer able to carry on their duties. Change in value of the agency property or subject matter, including loss or destruction. So a common agent that we see are like real estate agents. So you sign a written agreement with the real estate agent to sell your house, and 2 months later, and let's say the agreement is for 6 months, 2 months later the house burns to the ground. That's an example of the change in value of property or subject matter because the house is destroyed and the agent can no longer sell it, obviously. Changes in the law making the agency illegal. So let's say you're in a state, for example, like Colorado, that has a medical marijuana or recreational marijuana type law, and you employ someone to grow that marijuana on your behalf so that you can sell it in your pharmacy. But then Colorado goes back another year later, even though your agreement is for 3 years, and they change the law making the sale of marijuana in any capacity illegal. Therefore, the change in the law makes the agency illegal and the agency agreement will be terminated. And also change business conditions or outbreak of war. So for example, many years ago, I was working in Kuwait and British Petroleum hired me to go work in pre-Soviet Georgia at the time to work on the development of their oil fields and the reconditioning and modernization of the oil fields. Because I spoke Russian, and BP wanted me to work out of the Anchorage, Alaska office. But between the time that we signed the contract for me to act on BP's behalf as their attorney on this job and my starting, which was there about 6 months, taking place at the time, civil war broke out in Georgia. So because of the outbreak of war, I was no longer able to carry out my duties as their attorney in this operation. Therefore, we were able to terminate the agency and no one was in breach of our agreement. Also, termination of agency can happen by operation of law when there's impossibility of performance by the agent or death or bankruptcy of principal or agent. So somehow something happens that the agent can no longer perform what they're doing for a variety of reasons, and the agency can be terminated, and then death or bankruptcy of either individual. There is an exception. If you remember a few slides ago, we talked about an agency coupled with an interest, and that is the exception for impossibility. If the agent's power coupled with an interest, then the agency doesn't terminate by the principal's revocation, loss of capacity by principal or agent, or death of either principal or agent. So for the example that we were using, Dan borrowed $100,000 from the bank using his property as collateral. Just because Dan dies, that doesn't terminate the agency. His estate still has a responsibility to pay back that $100,000 to the bank, or the bank has the ability to take that property in lieu of payment. And what is the effect of agency termination? After the agency terminates, the agent's express and implied authority ends. For example, Well, what they're cautioning you about is ex-agents may retain apparent authority that could bind a former principal. So unless the third parties that are dealing with the agent are notified in some way, that apparent authority would remain. Let's say you're operating an insurance company and you have the State Farm sign outside, or you have the Allstate sign outside, that type of thing. The person still has business cards that says they're an agent of State Farm. In that case, principals should reduce their risk of liability for third parties relying on the ex-agent's apparent authority by actual or constructive notice to third parties about agency termination. So for the example that I was giving you with the insurance situation, the principal should make sure that they take up all business cards, that they remove the sign on the doors, that they remove the sign outside, and notify any third parties that have been dealing with the agent on behalf of the principal. And to greatly reduce their risk, it's good to put out a notice, let's say in the newspaper or some type of trade journal, wherever their third-party clients might regularly deal with this agent, notifying these individuals or these potential customers that this agent is no longer acting on the principal's behalf. Okay, now we're going to look at tort and contract liability. If you remember from legal environment, tort is a civil wrong. So we're not talking about criminal liability. We're talking about where there's been an injury on a civil basis. And it might be negligence, it might be product liability, it could be intentional infliction of emotional distress, something like that. So a principal bears tort and contract liability for their own acts or omissions. A principal controls an agent, thus the principal is liable for the agent's acts or omissions. So if your computer fails, would you sue the company or the inspector who missed the problem? Most likely you'd sue the company. So let's look at contract liability first. Generally, a principal is liable on a contract made by the agent if the agent had express, implied, or apparent authority to make the contract. So express authority, principal has bound the agent to go out and purchase 100,000 widgets. And in that case, the contract that agent negotiates on behalf of the principal with a third party, the principal will be liable for payment on that contract. Implied authority, the example again of buying the widgets, the agent went out and borrowed money because they had the express authority from the principal to purchase the widgets. They borrowed money and there's a financial agreement and the principal is liable to pay on that financial agreement. Or apparent authority, if the principal does nothing to show that the individual does not have apparent authority, then they would be liable in that contract as well. So if you have someone in a convenience store and they're signing for liquor on behalf of the principal, and the principal hasn't done anything to indicate that that person does not have the apparent authority to sign for deliveries on the principal's behalf, then the principal is responsible for payment on those deliveries. Even if the agent lacks authority to contract, a principal may become bound to contract obligations by ratifying a contract made by an unauthorized agent. So if you have an example where the principal has told the agent that they want them to buy 4 Ford trucks to work in their business, and the agent actually went out and bought 5 vans, they did not have the express authority to buy the vans, they had the express authority to buy the trucks, but once the principal sees the vans, they start using them, and therefore they will become liable on the contract. So even though the agent wasn't authorized to act that way, because the principal started using the vans, they have ratified that contract and are therefore liable for paying for those vehicles. And that's what we talk about ratification. In ratification, a principal becomes obligated for an unauthorized act done by an agent or a person posing as an agent. The act in question usually is a contract creation, such as just what I explained. Ratification relates back to the contract creation and binds principal as if agent had authority, and it may be expressed or implied, and basic contract law applies. Now, we're looking at the contract liability of the agent versus the principal. An agent's liability for a contract depends on the nature of the principal. An agent who represents a disclosed principal is not liable on contracts made for the principal. So if the agent is selling insurance on behalf of Allstate and they disclose that Allstate is the principal, the agent is not responsible or liable on that insurance contract because they have fully disclosed that the principal is Allstate. Agents are liable on contracts made for a partially disclosed principal unless the parties agree otherwise. So unless there's something written in the agency agreement, if the principal is not fully disclosed. So the third party might know that there is a principal involved, but they don't know the actual name or the company or the individual's name who represents the principal, then the agent will be liable on that contract as well. And an agent is liable to third parties on any contracts made for an undisclosed principal. And this is really to protect third parties, because if they don't really know who they're contracting with, and they're not really being told who that third party might, or who the principal might be, then that agent is always liable on those contracts. Now let's look at the principal's tort liability. A principal may be liable for a tort in 4 circumstances: direct liability for torts, the concept of respondeat superior, independent contractor activities, and misrepresentation. We'll look at these separately. Direct liability is a principal may incur direct liability for an agent's torts because the principal is at fault and the liability need not be imputed. For example, the sales agent merely applied the dealership's deceptive sales policy. So that's where they have direct liability. If the principal says that we say that all of our used cars are certified when in fact they're not, and the sales agent merely repeats that to people that they're selling the cars to, then the principal will incur direct liability for that agent's torts. Under the doctrine of respondeat superior, which is Latin for let the master answer, a principal who is an employer is liable for torts committed by agents, 1, who are employees, and 2, who commit the tort while acting within the scope of their employment. The principal is liable for the employee's negligent and intentional torts. So even if the employee was acting within the scope of their employment and they're negligent and an individual is hurt or property is damaged, even though the employee itself, him or herself, was negligent, the principal will be liable in that situation. In this case, we have to look at the scope of employment. Generally, an employee's conduct is within the scope of employment if the conduct meets each of the 4 tests. The conduct was of the kind that the employee was employed to perform. The conduct occurred substantially within the authorized time period, so basically when the employee was supposed to be working. Conduct occurred substantially within the location authorized by the employer, and the conduct was motivated at least in part by the purpose of serving the employer. So let's say the employer has an employee that has to drive 25 miles out to a job site each day. So they come to the employer's site, they pick up their vehicle, they drive 25 miles out to the job site, they do the work, and they drive 25 miles back each day. So in the course of the employment of driving out to the job site, the employee negligently is driving but wrecks the truck and injures other individuals that are not in the vehicle and who are not employed by the employer, also known as the principal, then the employer is going to be responsible for that employee's acts. Now let's say the employee has driven to the job site, done their work for the day, and on the way home they stop, and instead of going straight back to the employer's place of work to drop off the truck, they stop at a bar and they get intoxicated, they get in the employer's truck and have an accident and injure someone. At that time, the court will look at these 4 tests to determine, was the conduct the kind that the employee was employed to perform? He was supposed to drive, yes. Did the conduct occur substantially within the authorized time period? The employee was released from the job site at 3 o'clock. He was supposed to return the truck at 4 o'clock. This is 10 o'clock at night. So this would probably fall outside that time. Did the conduct occur substantially within the location authorized by the employer? In this case, most likely it is somewhere along the line between the job site and the employer's place of work. And was the conduct motivated at least in part by the purpose of serving the employer? Going out and drinking after you've been released from work is, in this case, not serving the employer. In some cases, people do have cocktail parties, they bring clients out to dinner, and that might be an instance where the court would have to look a little bit closer at the details. So in this case, item number 1 and item number 4 would show that the conduct was outside the work specified by the employer. And in this case, the employer would probably be released from liability, but the court would look at all the surrounding details. So now let's look at liability for torts of independent contractors. We've been looking more specifically at employees. So since a principal does not control the work of an independent contractor, a principal is not liable for an independent contractor's torts, except the principal may be directly liable for negligent retention of an independent contractor. So if the principal knows that the independent contractor is doing shoddy work, is leaving dangerous situations out at the work site, that type of thing, but continues to hire that person, continues to use them on job sites, then they may be directly liable for the negligent retention of that contractor. Also, a principal is liable for harm resulting from an independent contractor's failure to perform a non-delegable duty. So if it's a very specialized duty and you attempt as a principal to delegate that to someone who, as a contractor who really doesn't have the skills or abilities to take care of that, then most likely the principal will be held liable. And a principal is liable for an independent contractor's negligent failure to take special precautions to conduct highly dangerous or inherently dangerous activities. So this is almost like product liability, or what we call, for example, not product liability, but strict liability. So if the principal hires an independent contractor to do something which is inherently dangerous, let's say the independent contractor is to use explosives to knock down a building, in most instances the principal will be liable for that independent contractor's act, regardless of what's happening along the course of that activity. And then there's liability for misrepresentations. A principal may be liable for an agent's false statements, either made directly, whether it's intentionally or negligently, or vicariously, where the agent's authorized to make true statements on the subject. An exculpatory clause may negate tort liability of the principal. And that's where the written statement says, I further understand. For example, within the contract, this statement says that I further understand that the agent has no authority to make any representations about the conditions of the policy. So if you sign a written agreement, you know there's an agent, you know there's a principal, and this statement is within that contract, then the principal will not be held liable for the agent making any type of false statement or misrepresentation. Now let's look at the other side of things, which is the tort liability of the agent. Agents are liable for their torts except when the agent exercises the privilege of the principal. So if the agent is acting on the principal's behalf and this principal has this privilege, such as the use of an easement across property, then they will not be liable for their torts. Another instance is where the agent takes privileged action to defend his person or principal's property, where the agent makes a false statement in conduct of the principal's business but doesn't know the falsity of the statements. So the agent's saying something that's untrue, but they don't know that it's untrue. They will not be liable for any damages arising out of those statements. Or where third parties are injured by defective tools or instrumentalities furnished by the principal. So if the agent is out working on behalf of the principal and the principal has supplied the agent to use defective tools or instruments, then the agent will not be liable for any injuries that are sustained by third parties. Okay, you've been asked to do 16 problems. The problems are noted, and we're going to go through each of these in turn, and you can follow along in your book as you go. Question number 1 talks about a principal and agent relationship requires A, and the correct answer is A, which is a meeting of the minds and the consent to act. And this is just a basic requirement of the principal-agent relationship. The requirements to form an agency relationship are an agreement between the principal and agent on the relationship and subject matter, legality of the subject matter, and capacity of the principal. B is not correct because principal-agency relationships do not require consideration, which is required in a regular contract. It doesn't require a written agreement unless it's subject to the statute of frauds, and a power of attorney is just a very specific type of agency-principal relationship. Now when we're looking at number 2, which of the following acts can a principal employ an agent to perform? Again, the correct answer is A, to sell real property. This is the act that a principal can employ an agent to perform. An agent can perform most acts the principal could lawfully perform, such as selling real property, which is an ordinary business transaction that we're all familiar with. Many states do require that any type of sale of property under the statute of frauds requires a writing. And voting, the answer to number B is incorrect. The answer B is incorrect because voting for a political candidate with the power of attorney is not possible. Voting is a personal issue. You can't delegate under C, commit a crime. You can't delegate to an agent to perform an illegal act. And no one can sign a will with the power of attorney. A will must be signed by the individual that is the subject of the will. Now looking at number 3, Simpson, Ogden Corporation's agent, needs a written agency agreement too, and the correct answer is C, purchase an interest in undeveloped land for Ogden. If you remember the slide about what's required in the statute of frauds, series of sales contracts does not require writing. If you need to hire an attorney to collect a business debt owed Ogden, it also doesn't require writing. Or to retain an independent general contractor to renovate the office does not require writing either. So only the correct answer is to purchase an interest in undeveloped land for Ogden, because all agency agreements that involve an interest in land require writing. For number 4, Noel gives Carr a written power of attorney. Which of the following statements is true regarding this power of attorney? And answer D is correct. It may limit Carr's authority to specific transactions. So remember, we have two types of power of attorneys. We have the general and the specific. The general, they can do any acts on behalf of the principal, and a special power of attorney, they can only do specific enumerated acts. And a power of attorney need only be signed by the principal. And it doesn't require it be for a definite period of time. It just determines how the principal signs it. And a power of attorney may continue in existence after Noel's death, and we call that a durable power of attorney, and that's on a state-by-state basis, although Georgia does allow durable power of attorneys. Okay, turning to number 6, the question is, Jenny Jones, a clerk in a lumber yard, decided to take a lunch break. Bob Smith came in to buy some nails. Not seeing anyone around, Smith sat down on the counter to wait. And then Walter Proctor came in to buy some lumber, and he thought Smith worked there. So Proctor asked Smith if the lumber could be delivered that afternoon. Smith assured Proctor that it would be done. He paid Smith and left. Smith kept the money, and he also left. Which statement is false? The correct answer is A, which means A is false. Smith had apparent authority to sell the lumber or agree to deliver it. Because Smith was not the lumberyard's agent, he did not have express or implied authority to sell the lumber, and he did not have apparent authority because no conduct of the principal induced Proctor to rely on Smith's authority. The principal had no idea that Smith was in there. He had no idea that Jones had left for lunch. So that did not cloak any apparent authority on Smith, who was just sitting around. B is not correct because Jones was in violation of her fiduciary duty as an employee. And C is not correct because the lumber company cannot be held liable for not delivering the lumber as promised because no apparent authority existed, as we just said. And answer D is also incorrect because Proctor can hold Smith liable directly for his promise. So Proctor can go after Smith for the money that was paid. Next we're going to look at number 8. Which of the following rights will a third party be entitled to after validly contracting with an agent representing an undisclosed principal? And the correct answer is C, performance of the contract by the agent. So the third party is entitled to enforce a contract against the agent of an undisclosed principal and against the undisclosed principal when the third party discovers the principal and elects to hold him or her liable. So example, when we talked about in the earlier slide, is that if the principal is undisclosed, then the third party absolutely has the right to go after the agent because they had no idea who the principal was. In the event that they also find out who the principal is in this process, they can go after the agent and the principal for whatever losses that were incurred. Next, we turn to problem number 9. Which of the following statements is or are correct regarding the relationship between an agent and a non-disclosed principal? Number 1 says the principal is required to indemnify the agent for any contract entered into by the agent within the scope of the agency agreement. And number 2 says the agent has the same actual authority as if the principal had been disclosed. And answer C is correct because both 1 and 2 are correct regarding the relationship. An agent can legally bind the principal only when the agent has authority, and the agent's authority is either actual, express, or implied, or apparent. An actual authority is the principal's manifestation of the consent for the agent to bind the principal to third parties and is not affected by non-disclosure of the principal's identity. An agent acting for an undisclosed principal cannot have apparent authority because apparent authority derives from the principal's action or inaction or from the agent's position. An agent who contracts within the scope of the agency relationship for a non-disclosed principal binds both the agent and the undisclosed principal. Furthermore, one of the principal's fundamental duties is to indemnify or reimburse the agent for any payments or expenses incurred in any contract entered into by the agent within the scope of the agency agreement. Next, let's look at number 10. Lee repairs high-speed looms for Sew Corp, a clothing manufacturer. Which of the following circumstances best indicates that Lee is an employee of Sew and is not an independent contractor? And the correct answer is C. Lee is paid weekly by Sew. The factors supporting the view that a person is an employee. An employee is any person who is hired by another person or business for a wage or fixed payment in exchange for personal services and who does not provide these services as part of an independent business. So when the thing says Lee is paid weekly by Sew, this best fits the description of an employee. Most independent contractors are not paid weekly. They are paid at the end of their job or at a specific set of tasks. So if they have 4 tasks to complete, they might be paid 50% of the way through. They might be paid at the end, or they might be paid at the completion of each task. But they're generally not paid on a weekly basis or a bi-weekly basis like a regular employee would. Okay, next we're moving to number 12. What fiduciary duty, if any, exists in an agency relationship? Answer C is correct. The agent owes a fiduciary duty to the principal. So the agent owes a fiduciary duty to the principal, and the agent may not profit at the expense of or compete with the principal and must also disclose material facts and obey reasonable instructions. Okay, now we're going to look at number 15. Smith has been engaged as a general sales agent for the Victory Medical Supply Company. Victory, as Smith's principal, owes Smith several duties that are implied as a matter of law. Which of the following duties is owed by Victory to Smith? The duty not to compete is incorrect. B, to reimburse Smith for all expenditures is incorrect. C, not to dismiss Smith without cause is incorrect. So D is your correct answer, to indemnify Smith for liability for acts done in good faith upon Victory's orders. A principal is under a duty to indemnify his or her agent for liabilities and to reimburse him or her for expenses incurred while acting in good faith upon the principal's orders. Number 18. Okay, number 18 says Blue, a used car dealer, appointed Gage as an agent to sell Blue's cars. Gage was authorized by Blue to appoint subagents to assist in the sales of the cars. Vaughn was appointed as a subagent. To whom does Vaughn owe a fiduciary duty? Answer C is correct. Vaughn owes a fiduciary duty to both Blue, the car dealer, and to Gage, the agent. If the agent is authorized to appoint a subagent, the subagent is 1. An agent of both the principal and the agent, 2. Binds the principal as if he or she is the agent, and 3. Owes a fiduciary duty to both the principal and the agent. Okay, now let's turn to number 20, which is talking about ratification. Ratification gives you 4 statements, and the correct answer is C. Ratification requires the principal to ratify the entire act of the agent, and the ratification is retroactive, meaning it goes back to the time that the agreement went into place. For a principal to ratify an unauthorized act of an agent, the entire act must be ratified. Otherwise, a principal could pick and choose from unauthorized acts by agents, which would be unfair to the third parties with whom the agent is dealing. Ratification is also retroactive, which means it relates back to the time the agent entered into the contract. Okay, now we're going to look at number 23, and we're almost done. We just have 4 more. Delta sent its agent, Otto Bismarck, to purchase some equipment. Bismarck was instructed to charge the purchase to Delta's account. However, Bismarck charged it to a personal account and did not indicate it was for Delta. Upon returning to Delta, Bismarck showed Delta the personal charge and Delta reimbursed Bismarck. Later, Bismarck disappeared and the store seeks to hold Delta liable. Okay, so Bismarck purchased things on behalf of Delta but charged it to their personal account. Bismarck got reimbursed by Delta but then disappeared and did not pay the store. So which answer is correct? The answer D. Delta is liable because Bismarck was instructed to make the purchase. So Bismarck had express authority to make the purchase and did so on behalf of Delta. Thus, Delta is liable for the purchase price. This is similar to the situation in which an undisclosed principal is held liable for contracts entered into by its agent. A few cases take the view that because the agent's credit was originally trusted, the principal should not be required to pay twice. In jurisdictions following this view, the store could not recover from Delta. So even though Delta paid Bismarck, because Bismarck was acting on behalf of Delta, Delta would end up having to pay twice, and that would be the situation in Georgia as well. Now we're going to look at number 26. For which of the following is a principal liable for damages caused by an independent contractor acting on behalf of the principal? And answer B is correct. A dynamite explosion. If you can remember, we talked about a principal is generally not liable for the acts of an independent contractor. However, strict liability is imposed when the activity is ultra-hazardous. The use of dynamite has traditionally been considered an ultra-hazardous activity for which a principal can be held liable for damages caused by an independent contractor. Now look at number 27. Wanamaker Inc. engaged Adolph Anderson as its agent to purchase original oil paintings for resale by Wanamaker. Anderson's express authority was specifically limited to a maximum purchase price of $25,000 for any collection provided it contained a minimum of 5 oil paintings. Anderson purchased a 7-picture collection on Wanamaker's behalf for $30,000. Based upon these facts, which of the following is the correct legal conclusion? Answer C is the correct answer. If Wanamaker rightfully disaffirms the unauthorized contract, Anderson is personally liable to the seller. Because remember, he was authorized for a maximum purchase price of $25,000, a minimum of 5 oil paintings. He purchased 7 oil paintings, but he paid $30,000. So an agent who enters into a contract without authority can be held personally liable by the third party on the theory of breach of warranty of authority. If Wanamaker does not disaffirm the contract, however, Anderson's Act will be ratified and Anderson will not be liable. Okay, and for our last one, number 30, Young was a purchasing agent for Wilson, a sole proprietor. Young had the express authority to place purchase orders with Wilson's suppliers. Young conducted business through the mail and had little contact with Wilson. Young placed an order with Vanguard Inc. on Wilson's behalf after Wilson was declared incompetent in a judicial proceeding. Young was aware of Wilson's incapacity. With regard to the contract with Vanguard, Wilson or Wilson's legal representative will, and the answer is B, not be liable because Young did not have authority to enter into the contract. Remember that an agency relationship is terminated by operation of law if the principal becomes legally incompetent. Some exceptions apply, but they are very specialized and we're not going to get into that at this point. Apparent authority ceases upon termination that occurs by operation of law. Okay, so that includes us looking at the information and text about agency and the 16 problems. You now should be ready to go into your quiz number 2, and remember that quiz number 2 has 5 either true, false, or multiple choice questions worth 5 points each and 1 essay question. Before looking at the essay question, look at the IRAC method document that's part of this module. It will show you how to use the issue, rule, application, conclusion method to answer your essay question.